I'm Graham Paddock. I want to talk to you about a recent court case. In the Coral Island Body Corporate versus Hoge case, the body corporate employed advocates and attorneys in a high court action against an owner when the dispute could have been determined by the Community Schemes Ombud Service for R150. The High Court judgment records that about 2 weeks before the hearing in May 2019, Ms. Hoge backed off and agreed to all the trustees' demands. She had determined that the cost of compliance with those demands would be less than R10,000, and in this context, she was unable to afford the cost of litigating the dispute in the High Court. The judge, the Honourable Mr. Justice Binns Ward, gave an order that reflected the parties' settlement of what he described as a simple and uncomplicated dispute. And he said, it was undoubtedly inappropriate for the trustees to have proceeded for the relief that they sought in the current matter in the High Court, rather than through the Community Schemes Ombud Service. He stated that such actions should be discouraged by way of costs orders, and accordingly he made no order as to costs. This in effect meant that the owners at Coral Island will have to pay the body corporate's High Court legal fees and disbursements. The judgment records that the trustees were subject to a spending limitation. They had been directed not to incur any unbudgeted expense of more than R25,000 without first obtaining owner authority. This they did not do before launching the High Court action. They also appear to have breached the requirements of Prescribed Management Rule 9C, which obliges trustees to apply the body corporate's funds in accordance with budgets approved by members in general meeting. However, the text of a judgment cannot be expected to give the full story. It never does. There are many unanswered questions. I'm going to go through just a few of them. Why did the trustees and their legal advisors decide to go to the High Court rather than to the CSOS? Was it a tactic to force Ms. Hoge to incur substantial costs and thus encourage her to settle on their terms? Did they have no confidence in the CSOS processes or its adjudicators? Were the trustees properly authorized to expose the body corporate to the risk of legal costs? These might have included Ms. Hoge's legal expenses if she had been successful. In her pleadings, she had originally claimed that the trustees were not authorized, but because of her settlement concessions, the judge stated that he didn't have to decide this issue. He did, however, raise it quite pertinently. Why would the trustees ignore a spending restriction? Why would a managing agent, an attorney, or an advocate advise them to do so, even when they knew that this would come to the court's attention because it was in the papers? If the body corporate has to bear a loss, could the trustees be liable? And if so, could the body corporate now make application to the CSOS to recover its loss from them? Does the scheme have trustees' insurance that would cover such a loss? So there are many, many questions, but let me boil it down to 3 messages that I think this case has for trustees. 1, don't ignore spending restrictions. 2, don't go to the High Court when you can go to the CSOS. And 3, check the annual budget before making any instruction to attorneys or any other spending decisions. Thank you for joining me.